In 2016, the Canadian government was found to be racially discriminating against First Nations children by underfunding child welfare in such a way that it was driving First Nations children into care at higher rates than residential school. And the other thing that was discriminatory is Canada was not applying something called Jordan's Principle to make sure that First Nations children had access to the public services they need when they needed them. The government paraded out some ministers, they welcomed the decision, and then they didn't comply. So it is now 5 years later. We've had 19 non-compliance and procedural orders against the Canadian government and counting. And this week, the federal government was challenging two of the orders that the tribunal made. The first was to compensate the children that Canada willfully and recklessly discriminated against. And what I mean by that, Libby, is the tribunal found really clear evidence that Canada knew that these kids were being treated unequally, knew that that was driving family separations unnecessarily, and decided not to do anything about it, had solutions and didn't act. And the result of that is thousands of unnecessary family separations at a greater scale than residential school, harms to children who are denied services, and tragically, the deaths of children. The tribunal awarded $40,000 in compensation. That's not a lot of money. These are human rights damages. That's the most they can award under the Act, which is something I'm hoping Leah's going to take up in Parliament and revise. But Canada doesn't want to pay that. So Canada is arguing this week. They're saying, well, you know, it's not okay for a child who was in care for what they called 3 quiet nights away from their families. I don't know if they've ever seen a child welfare removal, but I have, and they would never describe it that way. They said that child doesn't deserve the same as other children. And I said, well, $40,000 is the floor, and if you want to give more than that, you can do it. The other thing they're challenging, though, Libby, is Jordan's Principle for First Nations children who do not have Indian Act status. As you know, that racist Indian Act was the piece of legislation Canada relied upon to push children into residential schools. It's still on the books. And Canada says, we only want to help First Nations children who have that racist Indian Act status. And guess who controls the definition of who is and who is not status? The Canadian government. We reject that. So in my view, I think that the evidence is really clear. Canada has relied on a lot of rhetoric, and we reply with the evidence and with the rulings. And I think Canada's arguments are very weak, and I think that they're collapsing under the weight of the truth. We'll have to see what the federal court does, but it's really, really critical that everybody keeps watching this case, because every time in history when we've had a crisis in First Nations, Métis, or Inuit communities and the public emotions rise and then they look away, the injustices continue by this federal state. We have to keep watching until the injustice stops.